Richard Brady, for example, this is a year old, going on a year old, and not much was done like the other ones. It's almost a year old. It's a state jail felony. And the stats of not only the court, the other court in this county and in other counties. And we shouldn't, announcements should be in a matter of months, and a disposition needs to be we're still in the very first stage, and it's not your fault, but why? And I know in this case, but he was indicted in October 23rd, on October 23rd of last year. And
On Brady, Judge?
I'm looking at Richard Brady.
I have a few cases.
He's got 3.
Okay, this is just the first one. 24 CR 454. Then 24 CR 245, I'm sorry, 2454. It's this one. And then I'm sorry. 24 CR 2454. The first one indicted 12/18 of 24. Then 24 CR 2455 was indicted all day the same day, 12/18 of 24. And then the third one is 24 CR 2198, and that indictment was October 23rd of 2024. So he's got 3 of them, and there's not really anything that's been done except just resettings. I mean, this is what's frustrating. This isn't going to happen. It's they go back. It's the same. First resetting was November 20th of last year. Second resetting, December 24th. Third resetting is January 25. So it's on. I mean, it's just stalling. But it was crazy, and that's not. I can understand that was different. Back. I never feel the next one, fifth one, March 17th, 6th, April 14th.
I'm thinking some just exact it's not just that. Can't test this one right now.
Try to open box. We got to do that.
7th and June 3rd. And those were all different from fighting.
Yes, it's very specific to what happens.
July 18th was the next one.
It's a specific update.
And then August 21st, that's 10 resetting. I mean, that's 10 settings, and we're on a state jail felony. It wasn't that hard.
To be fair, Judge, he has 2 second-degree felonies.
I'm looking at 2198, and then you're right, but I mean, still 10 resettings on anything is capital murder is long. Yeah, I mean, the indictments here are 20 a year ago, and then
this case has been reset 10 times in less than a year. 10. That's not just a delay, that's a courtroom merry-go-round. We've got indictments piling up, serious felony charges on the table, and yet nothing is moving forward. Why does justice feel like it's stuck on repeat here? And more importantly, who's really benefiting from these endless resets? Stick around, because this courtroom drama is about to heat up.
Going on a year ago in a month, then he gets the other 2 on December 18th, which is interesting because Why would anybody? Yeah. He posted a bond in 24 CR 2198 on September 9th of 24. The indictment, I guess that was when he was arrested. Then the indictment in 24 CR 2198 occurs on October 23rd, 2024. So he's indicted on 10/23/24. And
His dad and they. He's supposed to be.
while he had posted a bond while that indictment was pending, it's alleged he commits these 2 second-degree felonies on my watch, which are aggravated assault with a deadly weapon, 2 aggravated assaults on December 7th after he. What's his bonds in these two? In 2455 and 2454. Because he did that after he had posted a bond and was on indictment on previous things.
$30,000.
On each one?
I'm looking at the other one. Just to make sure of it. Correct. On each of the aggravated assault cases, it's $30,000 each. On the theft of a firearm, it's a $5,000.
Yeah. All right. Okay, what's our announcement? We've been doing this for about 8 resettings. And I know you're new, but that's why we've changed for the better.
I understand.
Moving things forward.
Just got this. I met him this morning because of the contact information. I understand the court's frustration, but
yeah,
also at the same time,
his bond, even still over there, I'm considering increasing your bond based upon the circumstances of all of this. So what are we going to do today? Just reset it again?
If I would ask for one more reset to get so I can actually sit down and talk with him about his case, because like I said, Judge, when on all the case information today, all of it came up without any sort of contact information. All of them were out on bond. So I'm literally being able to meet with him for the first time as we're meeting in court today. It's not meant to be dilatory. It's just meant to be.
Why aren't we meeting them though? Like before we get to you, I can maybe work on some other ones. Maybe y'all can talk about with everybody. They're all here. Let's see if there's something that can be accomplished now that they're all here. Otherwise, we're going to all take off, and then you're going to have to chase them down on a phone call.
I agree. It's just the court was starting to call names when we were meeting.
Okay.
While the court keeps hitting the reset button, the defendant is out on bond, facing not one, but multiple aggravated assault charges. And get this, each bond is set at $30,000, yet he's still out. The judge is clearly frustrated, even hinting at increasing those bonds. But here's a question for you. Do repeated resets give the defense too much breathing room, or is this just how an overburdened system works? Drop your thoughts below, because this is where courtroom strategy collides with real-life consequences.
You or Harlan, 25 CR 111 is called the state of Texas versus Harlan, and your middle name is Dreamist. Did you know that?
That's good.
I don't think I've ever known that. I've never heard that. Briggs. And you are here with your attorney, Ms. Minaldi, and the state's attorney. Does the defendant waive a formal reading of the indictment and arraignment here? Can we proceed in summary?
Yes, Judge.
In summary, this indictment alleges that on or about December 17th, 2024, in Jefferson County, Texas, you committed the state jail felony of burglary of a building. Do you understand what you're charged with here, sir?
Yes, sir.
A state jail felony, if convicted, means that you face a term of imprisonment in the state jail no less than 180 days, no more than 2 years. And in addition, a fine may be assessed not to exceed $10,000. Do you understand?
So
Punishment rate.
It says, which fine it all. Illegally, it's just one of them, so.
I'm going to show them what we have to do to write on this stuff. while he was here. Because that's the way this pants work or don't work. An agreement has been reached in your case. You would be pleading guilty, sentenced to 2 years in the state jail. That would be suspended. You would be placed on regular probation for 5 years, ordered to pay restitution in the amount of $482.86 to the complainant in this case. Is that your understanding? That's who's named in the indictment. Is that your understanding of the plan?
Yes, sir.
If I follow this agreement, you have no right of appeal. Do you understand?
Yes, sir.
How do you plead to this, sir? Guilty or not guilty?
Yes.
Are you pleading guilty voluntarily? That is on your own free will and because you are guilty? You have self-awareness. Okay. I show you what's marked as State's Exhibit 1. Did you sign that document voluntarily? Understand it? Discuss it with your attorney? Are the contents all true and correct?
Yes, sir.
State's Exhibit 1 is tendered into evidence, and without objection, it's admitted. Among other things, this states you are mentally competent to enter your guilty plea, and it's completely involuntarily made. You know what you've been charged with, because it's been read to you. You've read it. You are guilty of the crime charged in any lesser included offenses, and you are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. Totally satisfied with the representation provided by your lawyer. All of this is true, so help you God.
Yes, sir.
State's Exhibit 1 is made a part of the record for all purposes. Pre-sentence report is made. And again, how do you plead to this, sir? Guilty or not guilty? You're pleading guilty voluntarily and because you are guilty.
So,
All right. I'm going to make the following findings that you are indeed, the court finds, pleading guilty voluntarily. You are mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence from State's Exhibit 1 admitted here to support your guilty plea to find you guilty beyond a reasonable doubt. And I now find you guilty beyond a reasonable doubt of this state jail felony of burglary of a building. I am following this agreement. You are hereby sentenced to confinement in the state jail for 2 years. That will be suspended. You were placed on regular probation for 5 years. And restitution, among other costs, will be paid in the amount of $482.86 to the complainant in this case.
All right, big moment here. The defendant just agreed to plead guilty, but listen closely. Instead of serving 2 years behind bars, he's walking away with 5 years probation and just $482.86 in restitution. That's less than the cost of a new iPhone. The judge makes it crystal clear. Pay back the victim and do it fast, preferably before Christmas. What do you think? Is this a fair balance between accountability and a second chance? Or does it feel like a slap on the wrist?
When can that be paid?
my first payment will be on the 20th.
When can? No, that's not the answer.
Can you pay it off? Is there
I want him paid as soon as possible because, for example, like this is going on a year old, and whatever they lost, they've lost it now for a year. You got to get the money, reimburse the person.
So you make like 30 days.
How much time do you need for $482.86? Because I want that paid first.
He can for sure commit to $100 a month, Judge, but if he can pay it all off quicker than that, then he will.
You got 4 months to do it. Okay. No, I'm going to let's get this before Christmas. 3 months. Okay.
Okay.
That's 90 days. All right. There will be other terms and conditions which are normal and customary. If you do well, your probation is shortened to 1/3 of the time.
You gotta right my wrongs, Judge.
Okay, fix it. We'll fix it.
So I get it straight today.
Yes, sir. Okay, good. Thank you. Anything else? Thank you. Please seek probation. Next is DeMarcus Jones.
Yeah.